My task for tonight, which I volunteered for, is to introduce to you the tools that there are in the Mental Capacity Act for allowing more support for decision making than we have through supported decision making in Principle 2 and best interest decision making. And those were two things that we spent a lot of time talking about in our last session, the second session of the CLARiTY project. And those of you who weren't there, please do have a look at the summary of the last session so that you know what we're talking about when we're talking about supported decision making and best interest decision making. So I'm going to be talking about the extra tools, and I did mention those last time, and there's 4 extra tools that I want to talk about from the Mental Capacity Act. 2 of them we're going to talk about a lot, and 2 of them we're only going to talk about a tiny little bit. So these are tools. There are things that you can use if you want to or need to in order to get more support with decision making or have more choice about who makes decisions than under the broad sweep, the broad framework of the Mental Capacity Act. Before we get started on how we use those tools, a quick little reminder. Nobody can be considered to lack capacity to make a decision unless they have been given support to make it, and that support hasn't helped them to be able to make the decision. So supported decision making always comes first. We don't ever jump straight to these tools that help us to make other decisions. So these are tools for when someone can't make a decision for themselves, but they always come in after we've tried to support them. Disabled people always have the right to try and make the decisions about their own lives and have choice about what happens to them. And that's a fundamental that we must never get away from. Okay? Sometimes people need more help though. And as well as supported decision making and the general best interests framework of the Mental Capacity Act, there are 4 other legal tools. There are lasting power of attorney, which we're going to talk about a lot, deputyship, which we're also going to talk about a lot, and there are advanced decisions to refuse treatment and advanced statements. And we're not going to talk about these last 2 very much at all. But all 4 of these tools apply to people who are age 18 and older. Okay, so that's different from the General Mental Capacity Act, which starts at age 16. So best interests and supported decision making starts for everyone starting at the age of 16, but these tools are for people who are over 18. Okay, the advanced decisions to refuse treatment are formal legal documents. They don't have to be written down, but it's better if they are, because then it's clearer and it's easier to share them with people. So if you have capacity to consent to or refuse medical treatment now, you can make an advanced decision to refuse particular kinds of treatment that you don't want to have in the future. And that's called an advanced decision to refuse treatment. You might want to do that if, say, you know that in the past you've been treated with a particular drug or kind of drugs which make you feel really bad, or you get bad side effects from, for example. You can make a legal document that says, I don't want to have those drugs if I get sick in the future and I don't have the capacity to say no to them then. There are some exceptions to when advanced decisions to refuse treatment can be used, and there are specific rules about them. We don't have time, we didn't plan to put this in, but I wanted to tell you all about that this exists. And so at the end, we're going to have a bit of a talk about what we're going to talk about next time. And if you'd like more information about advanced decisions to refuse treatment, we can talk more about it then, okay? Advanced statements are less formal kind of ways of saying what you would like to happen or what you like and what you don't like. Some of you who were with us in the first session will remember that we talked a bit about hospital passports then, and we've got some links to information about hospital passports in our summary from the first session. So hospital passports are a kind of advanced statement. They're a way of you expressing to people what you would like and don't like, and would like to happen if you go into hospital, or wouldn't like to happen if you go into hospital. You can tell people how you communicate and that sort of thing. They can be really useful tools. So those are two tools that we're not really covering in this session, but I wanted to talk about. Okay, and Magda's put a link in the chat to our summary from session 1 and session 2 to tell you about that. So the two things that we do want to talk a lot about this week, and that we advertised about this one, are lasting power of attorney and deputyship. And under the Mental Capacity Act, there are two kinds of lasting power of attorney documents and two kinds of deputyship appointments, which is a bit confusing, but they're the same two different kinds of each one, if that makes sense to you. Lasting power of attorney and deputyship are quite similar in terms of the role that the person who is the attorney or the deputy has. They are both legal powers to be able to make decisions on behalf of another person. So if, say, a person with learning disabilities doesn't have capacity to make some decisions in their lives, they might have a lasting power of attorney or a deputy, and that would name another person who would make the decisions on their behalf. The big difference between a lasting power of attorney and a deputyship is who chooses who the person is that has the authority to make the decisions. So if it's a lasting power of attorney, you choose for yourself. If it's a deputyship, the Court of Protection chooses who that person is, and that person might apply to the Court of Protection to have that appointment, but the choice is up to the court. So I said there are two different types of both of them. For both lasting power of attorney and for deputyship, you can either have a power to make financial decisions, like managing money, bank accounts, investments, savings, budgeting, that kind of thing. Or you can have a power to make decisions about health and welfare, consenting to medical treatment, where you live, that kind of thing. Or you can have both, and you can have one person who has a power of attorney to make decisions about finances, and a different person who has power to make decisions about health and welfare, or they can be the same person, or there can be multiple people on either. And the same for deputyship. So there are the same two different types. But in order to be able to make decisions about health and welfare, you need a health and welfare power. So if you've got a financial power, you can't then make health and welfare decisions, although you might sometimes be consulted about best interest decisions, but you don't have the power to make that decision. There are approximately 4.5 million current powers of attorney registered with the Office of the Public Guardian at the moment. The Office of the Public Guardian, they're based in Birmingham, not too far away from my campus that I'm not allowed to go to again because it's locked down. But they register power of attorney, so when you make one, it gets sent to them. And when it's registered, it can be used. So there are about 4.7 million, just over 4.5 million current powers of attorney on the register. The vast majority of those are financial powers. There are far fewer health and welfare powers, in part because health and welfare powers only started to be available when the Mental Capacity Act came in, which was in 2007, whereas there was a different kind of financial power of attorney before that law. Okay, so deputyship. There have been a total of around 160,000 financial deputyship orders made since the Mental Capacity Act came into force, but only just under 3,000 health and welfare deputyship orders made by the Court of Protection. So what do all these big numbers tell us? They tell us that power of attorney is more popular, more people have them, more people use them. Deputyship is less popular, and health and welfare deputyship very rarely happens.